Nah ini sesuai prosedur. Kapan orang enggak ada. Ya, enggak bayar Henry balik sana. Biar enak lagi tuh. Enggak ada. Ini belum diambil. Kalau udah diambil, nah ini seluruhnya enggak. Enggak nama Henry. Iya, biar. Belum ada. Kalau ini dapat 300 doang. Lah iya, 300. Kemarin enggak bisa jalan. Hah? Kemarin enggak bisa jalan. Enggak bisa pergi. Enggak duit.
Ini tak kirim. Nah, dia gitu ya.
Hello, check. Can you hear me clearly? Halo Bang Ardian, can you hear my voice clearly? Halo Mas Adrian, bisa dengar suaranya dengan jelas?
Oh, udah.
Oke. Yan, itu nyolokinnya yang mana sih? Dia 2 lubangnya. Yang USB tadi tuh. Belum aku colok.
Oh ya, nanti aku ke situ.
Oke. Hello, Professor Warren. Good.
Hi, Ari. How are you?
We're still waiting for the director of graduate school and also Professor Susi. How was USA right now after the Minneapolis accident? Is it okay or?
Well, things in the USA are very difficult because of the coronavirus. You know, the rate of infection is still very high here. And so we are all still in quarantine.
Okay. So how was the education? I mean, the higher education dealing with the situation? Because in Indonesia, we do our semester, I mean the next semester with the online course.
Yes, well, it's very complicated, but I think what we are going to do is a mixture of online teaching and in-person teaching. So some of my classes will be in person, but we will be wearing a mask and we will have plastic protective shields, and there will be plexiglass in between the students. So I think it's going to be difficult.
Yeah, some agenda in Indonesia also postponed. For example, the national conference will be held in this year, will be postponed in the next year. But the concurrent local elections still going on in Indonesia. I think it's like the tragedy.
Yeah, I was wondering if you were going to be having your big conference again this fall, but I guess not.
Yeah, no, it will be held on this next year in the 2021.
I think that's smart. Is everyone there healthy? Do you know anyone who has had coronavirus?
Kalau share screen-nya nanti diambilnya dari sini, ya? Kalau mau what? Sorry?
Ya. Nanti dibuka dulu.
Oh, dibuka dulu. Sorry, Professor Warren, we check for the PowerPoint process. Keluar ya?
Itu sekarang jaringannya.
Oh, lagi ya? PowerPoint-nya di apa USB? Dia ada 2 sih, ada PDF sama PowerPoint. Oh, bukan yang ini. Yang ini PowerPoint-nya, terus PDF-nya yang satu lagi. Ada nih, aduh. Berlari-lari jadi kalau pagi-pagi nih. Berlari-lari gitu jadi karena panik. Jadi nanti tinggal share screen itu. Oke, apa yang ini apa? Yang ini satu lagi. Nah, yang khusus ini logonya dibuka ini nanti. Dan takut dia. Sorry, Prof. Warren, we still try to organize the PPT first.
So you have the PowerPoint, right?
Yes, I have the PowerPoint. We try that to word it.
And you have the chart also, Ari?
What?
Do you also have the chart?
Yes, we have.
Okay.
Okay, yeah. Okay, thank you. Our director of graduate school is already joined us, Professor Herlambang. Welcome, Professor Herlambang.
Evening of Padjajaran.
Prof. Warren, this is Professor Herlambang, our director of School of Law in the University of Bengkulu. He also professor in the criminal law department, Prof. You want to say hi, Professor Herlambang, to Professor Warren?
Okay. Good evening. Maybe it's not. Okay. Thank you for the lecture today. Important for us to make some comparison about the judicial system in America. I hope you enjoy the lecture, sharing your knowledge about this. Okay. Good evening.
Okay, thank you. I think we're still waiting for Professor Susi from Padjajaran University.
I hope the sound will be all right because it's a little bit in and out.
Okay.
Ari dengar? Ari dengar?
Ya, Prof. Yes,
dengar,
ya, Prof.
dengar suara saya?
Oh, dengar. I can hear your voice, but its sound is not clear. Quite.
Oh.
Yeah.
Okay. Maybe Professor Warren not here. Okay.
Morning, Prof.
Okay, Ari, this better? You hear?
Yes, I can hear. Can you hear Professor Herlambang, Prof. Christie?
Yes.
Is it clear?
Okay.
It's better now, yes.
Thank you. Professor Warren, how about the pandemic in the EU country? It's now lockdown or increase of the number?
I'm going to try my earphones to see if this is better.
Ari, maybe
I think that it will be better for Professor Herlambang also to use the headset so you can speak very clear.
yeah, not used to headset.
Do you have a headset?
But if I use this, my voice is not clear. Now, Now better? No? Clear?
Okay, morning for the all participants also. Welcome to the webinar series. I think that for you, the participant coming from overseas or abroad, you can say hello in the chat box also, and by saying your nationality or your citizenship, so we can recognize the people who come from overseas or abroad. We're still waiting for Professor Susi. I think that is still prepare herself.
Morning, Prof. Lambang.
Ah, there's Susie.
Prof. Susi. Halo, Prof. Susi. Ada.
Selamat pagi semuanya.
Welcome, Prof. Susi.
Hi.
How are you?
Fine, thanks.
Okay.
Hi, Prof. Warren.
Nice to see you again.
Yeah, it's such a long time.
Well, 1 year, right? I think it was last year we saw each other.
Last year
I think
or 2 years ago?
Yeah.
Or
I
2
think
years ago.
2 years ago, 2007, 2019, 18, right? 2 years ago.
Yeah, 2 years ago.
Yeah, in the
2018.
Batu Sangkar.
In Batu Sangkar, yeah.
That's right. How have
Yeah.
you been?
Sorry?
How are you?
Good, thanks. But here in Indonesia, particularly in Bandung, we have work from home since March, I think.
We are the same.
Yeah.
I'm a little bit tired of it. I would rather be in Indonesia.
To buy some children too, right?
There's already 200 people signed in.
Yeah,
106.
we have 1,030 people registered, but we don't know who is join us in the Zoom or in the YouTube channel, because we also live in the YouTube channel. Prof. Herlambang udah bisa dimulai atau masih mau nunggu dulu?
Pagi, Prof. Susi, right?
Prof. Susi, Prof. Herlambang, Prof. Pasca. Prof. Herlambang, kita mau mulai atau masih nunggu?
Dan suara saya, oke?
Suaranya belum jelas sih kalau yang Prof sih, dia saya apa ya?
Halo, Hari?
Oke, Prof, udah mau dimulai atau gimana, Prof?
Boleh, silakan.
Mulai, Prof. Oke, mulai ya. Oke, Professor Susi and Professor Christie, we start our webinar series. All participants, Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Salam, Om Swastiastu, Namo Buddhaya, salam kebajikan untuk kita semua. Good day, ladies and gentlemen, and also the participants of the Stadium General. My name is Harijanti, a senior lecturer at the Faculty of Law, Universitas Bengkulu. Honestly, it is such an honor for me to moderating this public lecture. As known, this public lecture is organized by Program Magister Hukum, Nadir School of Law, Faculty of Law, Universitas Bengkulu. This event is a part of commemoration 38 years anniversary of Faculty of Law as well as Universitas Bengkulu. Ladies and gentlemen, and also all participants, before we begin this event, I inform you some guidances. One, the Studium General will discuss concerning to a comparative law study on judicial power between Indonesia and USA. Two, this event will be moderated by me and hosted by Adrian. Both of us have authority to turn your microphone on and off. So please, when you join this, please mute your microphone. Three, this event will spend approximately 2 hours divided 4 agendas. First, opening and reporting from faculty member. Second, lecturing by 2 speakers. Third, question and answer session. And last or fourth, closing remark. Fourth, we allow the participant to write the question down into the chat box. I will pick some, then it will be answered by the panel speakers. Please make your question short, precise, and concise. And don't forget to identify yourself by writing your name, your nationality or citizenship if you come from overseas or abroad, and also your institution background. In the last of this program, I will or the committee will announce the best questions, and the best question will get the door prize sponsored by Professor L.LM. 5. Besides watching this public lecture in the Zoom meeting, we also provide the YouTube channel. So if you don't get the link or sit in the Zoom meeting, don't worry. Please check our official YouTube channel at FHUI. 6. We also ask all participants to fill their name in the list of attendance or presenting, because the certificate only will be given to the people who attend and join this event from beginning until the end. The list of attendance or presence link will be shared into the chat box as well as in the comment box of YouTube channel around 10 minutes before the event begins. I think this is the guidance of this webinar series. Ladies and gentlemen, first of all, I invite the Director of Graduate School of Law, Universitas Bengkulu, to convey his remark and officially open this public lecture. To Professor Dr. Herlambang SHFH, the microphone is yours, Prof.
Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam.
Kemarin dan Prof Susi yang untuk kedua kalinya mungkin bisa bicara di Bengkulu ya.
Ya, betul.
Today I would like to share to speaker, especially Professor Varel. It's not a morning, it's not day, but you have a time to ask your lecture, and the student program following like Hari tell us that maybe 1,000 more participants who register to this committee. But I hope they will follow the lecture and the participant from the academic student, not only the student, but also lecturer and the teacher and the practitioner or the NGO activities. Of course, they will know about the compare judicial power in America and Indonesia. And I hope that we will get the and broaden our knowledge horizon about the subject. This event is one of agenda of celebrating the anniversary of Faculty of Law, University of Bengkulu. And in this moment, I like to give a message from the Dean, Faculty of Law, we had sent a greeting message to all of us, but do not join this meeting because he have the another meeting. And without further ado, let us commence the Stadium General, and I hope we can enjoy this event. And as we say in bahasa, ikan cepat, ikan gabus, makin cepat, makin bagus. Mudah-mudahan semua sehat, bahagia hari ini. Terima kasih. Silakan kita mulai. Assalamualaikum warahmatullahi wabarakatuh. Thank you. Ari, the voice.
Can you hear me?
Okay.
Okay. Thanks for the remark from the Professor Herlambang. Ladies and gentlemen, and also all the participants, as the air traffic control in the panel discussion, I have a duty to introduce our speakers. Both of them are super prominent professors coming from two great democratic states. First, Professor Christie Warren. He is constitutional law professor at William and Mary Law School, USA. She also the director at the Center for Comparative Legal Study and Post-Conflict Peacebuilding. His areas of specialization include comparative law, comparative constitutional system, public international law, post-conflict justice, Islamic law, so on and so forth. Professor Warren has advised on constitutional issues and processes in Haiti, Iraq, Kosovo, Moldova, Somalia, Sudan, and Ukraine. Welcome, Professor Warren. Thanks a lot for accepting our invitation. Furthermore, our second speaker is Professor Susi Harijanti. She is the academician by training at the Faculty of Law, Universitas Padjajaran, Bandung. She graduated from Universitas Padjajaran for undergraduate program and obtained her master and Ph.D. from Melbourne University, Australia. Professor Susi is also head of Indonesian Comparative Legal Study Association. Welcome, Professor Susi. Thank you so much. It is your second time, right? Join our webinar series.
Hi.
Okay. Distinguished guests and all participants, even Indonesia and USA have similarity. For example, we are two big democratic states, the most population country all over the world, and also practice the presidential system. But there are several differences facing by the two countries. For example, in the judicial power. After the reformation and the amendment of our constitution, the big actor of judicial power in Indonesia is not only Supreme Court or Mahkamah Konstitusi, but also the Constitutional Court as the new institution or Mahkamah Konstitusi. The authority of the institution is quite different one and the other. On the other hand, the American legal system is only has one, called as the Supreme Court of America. Sure, the authority, the selection process of justice, tenure are different. Through this public lecture, we will discuss about it. Without further ado, I invite Professor Warren first to convey her views on it. Professor Warren will talk about an overview of judicial power in American legal system, and also will be addressed some key points, for instance, tenure of justice, selection process to be justice, requirement to be justice, and the other things. I think 20 until 30 minutes ahead is yours, Professor Warren.
Okay. Can everyone hear me?
Yes.
Okay. I will do my best to speak clearly and slowly because we're speaking on opposite sides of the world right now. But before I begin, I would just like to say that it's a real honor for me to be participating in this webinar and to see some familiar faces. This is the third time I think I have worked with Ari and his colleagues, and the second time with Professor Susi, and I'm just very proud to be speaking on the same program with them and to see all of you. So, yes. So I believe Ari will be controlling the PowerPoint that I will use. And I'm going to unplug this for right now, but I don't see.
Yeah, I tried to.
Yeah.
Yeah. Okay. Can you see the PowerPoint on the screen?
I see a list of your documents.
Okay. That is still on process. Wait for a moment.
I think, yes, you have highlighted it, but it's not open.
Okay. Can you see?
I still see the list of all of your documents on your computer.
Adrian, can you help us?
I wonder if I can do it.
Oh. Okay.
I don't know if anyone else can see the PowerPoint. What I see is just a list of documents. I can try to share it from here.
I think it just already worked in my screen. Can you see? No?
Not
No,
yet.
I cannot. Do you see it, Susie?
Not yet.
No, yeah.
Adrian, can you help us to make
List
this
of,
screen?
yeah.
I think I will try to ask to the staff to help us.
Mas Ari mungkin bisa ditutup aja Mas, karena ini list dari paper-paper yang ada di dokumen Mas Ari yang terlihat.
Oh, tunggu.
So I have the PowerPoint on my laptop. I can try and do the screen share from here. Do you think that might work?
Oh yeah.
Yes.
Okay, let me try that. Okay, can you see that?
Yeah, great.
Okay, so let's see if I can work there. Okay. Is that good?
Yes, it is good.
Yeah.
Okay. So this is the title screen. Now let's see if we can. Okay, so I'm going to speak generally for a few minutes just about the source of judicial review and the origin of judicial review in the United States, because it has a little bit of an unusual background. You know, people say, why do the courts have the right to review acts of Congress? Why do they have the right to review what the president does or a prime minister does? Why do they have the right to review what police do and even establish new law? So within our system, you know, I'm a lawyer, so I am biased. I will say that I think that judicial review really is the cornerstone of our democracy, that our democratic system would not function without the power of judicial review, just because it is the supreme check and balance to the exercise of judicial and executive power. So the source of judicial power, judicial review in our system comes from our Constitution. 1789, you know, after the Declaration of Independence, it was one of the first documents to be drafted by our founding fathers, who were founding fathers because there were no founding mothers at that time. And so our Article 3 says judicial power of the United States shall be vested in one Supreme Court and in such inferior courts, meaning lower courts, as Congress may from time to time ordain and establish. So this really is, I can see people are raising their hands, but I'm not going to take any questions until the end, if that's all right, just because I have a short period of time, and then I'll be happy to answer anything during the Q&A. But you can see that this Article 3, the language of Article 3 is very short. It's very brief. You would think if you're setting up a judicial system and establishing judicial review, that you would have a long, complicated series of detailed provisions about how the court will work. And in fact, this is all that Article 3 says right here. There are no lower federal courts that are set up in our Constitution at all. And so the Constitution, in this very short, concise sentence, set up only one court. So as Ari said, we do not have a constitutional court. We have only a Supreme Court, and it fulfills the function of both an appellate Supreme Court and a constitutional court. And I'll talk a little bit more about that in a minute. But it was during the first meeting of Congress, our legislative branch, the equivalent of a parliament, in 1789, that Congress enacted the first Judiciary Act, and it established an entire system of lower federal trial courts. So it filled in the gaps that were left in our Constitution. So it was not immediately set out. So this is an overview of our federal court system now in the United States. You can see that it is divided up into districts. We have 13 federal court districts, and each district is composed of different states and different numbers of states. So you can see, for example, that the first district, which is in the upper right-hand corner, is actually very small and has only 4 of the 4 original small states when our country was settled, and also Puerto Rico is included in there. And then you can go all the way west and you can see the 9th Circuit, which includes California, my home state, and it is the largest circuit. It is also the most liberal group of federal judges in our country. And the decisions that come out of our federal courts in the 9th Circuit are usually very different and much more liberal often than the decisions that come out of, say, the 3rd or 4th Circuits on the East Coast. So because our country is so big and there are so many lower federal courts now that try a lot of cases, and then go up through the appellate branches in each of these 13 circuits, you can see that the potential for divergent opinions coming out of the federal courts is very great, right? Because our country is much more liberal and much more conservative and has different local values depending on the specific area of the country. So one of the most important jobs of our Supreme Court is to interpret federal legislation and the Constitution, the federal Constitution, and ensure that there are no inconsistencies in the interpretations by the lower federal courts. So we'll talk about jurisdiction in a minute, but I think this map is very good just to show you how big and how diverse our federal court system is in the United States. And again, it was not set up in the Constitution. It was set up by the Federal Judiciary Act of 1789. So the power of judicial review really, and especially among lawyers, is considered to be the most important aspect of the work that the Supreme Court does. And what that involves is, as I just said, the power to interpret and nullify federal laws that happen to be inconsistent with the federal Constitution. So they are the constitutional watchdog, the Supreme Court. And in a way, that is the same work that a constitutional court does in countries where there is a constitutional court. And Professor Susi is an expert among many other things, including comparative constitutional analysis, but also in Indonesian law. So I imagine she will be talking to you somewhat about the work of the Constitutional Court in Indonesia. I won't talk about that, but I will say that a lot of the work that our Supreme Court does is very similar to the work that a Constitutional Court does. That is illustrated by the fact that the Supreme Court receives probably between 7 to 8 to 9 to 10,000 petitions every year asking it to review cases, and it only accepts approximately 80 cases. Not 80,000, not 8,000, 80, which is a very, very small number of cases. Now, some people complain about that and they say, oh, you know, the Supreme Court could do so much more work. It could take so many more cases. but the Supreme Court guards its power very carefully and accepts a case only when it is ripe and ready for review. And usually there are inconsistencies in the federal cases in lower courts that, that persuade our Supreme Court to take the case and resolve those inconsistencies. So you can say, you know, where did the Supreme Court get this power? Who gave it to the court to review federal legislation? In other words, to review things that the president does, branches, the executive branch acts, or to review federal legislation. Did Congress in the Judiciary Act give the Supreme Court that power? And the answer is no. It came from a decision of the Supreme Court itself, excuse me, in 1803 by our first Chief Justice of the United States, John Marshall. And that case is Marbury versus Madison. You may have heard of this case because I'm trying to remember, Ari, maybe it was you. There's who took me. There is like a museum, an exhibit. Where is that?
In Constitutional Court of Republic Indonesia, bro.
Okay, in the Constitutional Court, there's an entire corridor that has the history of Marbury versus Madison, including photographs of Chief Justice Marshall and quotations from the case itself. So, you know, I'm very proud as an American that this fundamental decision out of our Supreme Court has had this kind of influence around the world, because in a lot of countries, in a lot of democracies, it is the legislative branch, the parliament or the Congress, that delegates the power of review to a Supreme Court. But in our democracy, in our democratic system, it was the court itself that declared this power. And this was controversial at the time. This was not free of controversy, and yet it was followed. It was respected, and it has been followed ever since then. I will say it is still sometimes not free of controversy. People still, you know, question the power of the Supreme Court to review a lot of what the president does or what Congress does, but it is very good law, and it is a central part of our democratic system. So what kinds of cases does our Supreme Court hear? This is just a very broad overview statement here. The cases that the court accepts may depend on subject matter, the subject of the case. So if a case involves federal law, the court can accept it. If it involves only state law, the Supreme Court will not review the case or accept it unless there is an allegation that the state law violates federal law or violates the federal constitution. And then also the Supreme Court has jurisdiction in admiralty cases and maritime cases. So this involves shipping and things that happen on the sea and that kind of case, those kinds of cases. Or the Supreme Court can accept cases depending on who the parties are. So if the parties are ambassadors or other public consuls, or if the party is the United States or a state, an individual state, the Supreme Court has jurisdiction in the case. So these are very limited types of cases. If I get a traffic ticket driving to law school next week, and I believe I was wrongly arrested, and I'm very unhappy about it, and I want to take it all the way, and I'm very, very rich, and I have a long time, and I want to take it, I want to fight the case all the way to the Supreme Court of the United States, it is probably not going to get there. The court will not accept it unless there is an allegation that it violates federal law. Okay, so the third bullet point here, that the Supreme Court has original jurisdiction in a very limited number of cases, and the rest are arrive on appeal. What that means is you cannot go to the Supreme Court and have a trial, the original trial, and ask the justices, all 9 of them, to serve as jurors or to serve as judges and come to a verdict on your case. Very, very limited number of cases. In fact, honestly, I can't remember the last time that the Supreme Court took a case according to its original jurisdiction. It's very rare. The rest are appeals that have been tried at lower courts and gone through the appellate process and ultimately arrived at the Supreme Court. Now, the Supreme Court, even if a case is properly under its jurisdiction, the parties are all correct, the type of case fits within the limits of jurisdiction, there are still limitations on the Supreme Court power. And these are some of them. The case must be an actual case or controversy. And this is very different from the work that constitutional courts in particular often do in other countries, where the legislative branch will ask the constitutional court for an advisory opinion and say, we are thinking of enacting a law against A, B, or C. Can you tell us if you see any constitutional problems with that? And the constitutional court will say, well, don't phrase it this way. Instead, you should articulate it this way. Or, and the advisory opinion will be, no, you cannot properly legislate in that area at all. We don't do that, and that's illegal. There has to be an actual case between at least two actual parties that have proper standing. That's the second requirement here. Standing means that you are a party who has actually suffered harm. And the harm is not speculative, it's not theoretical, it's not prospective. You have to actually have suffered concrete harm. And if you haven't, you do not have standing. So for example, if my, let's see, one of my son is hit in an automobile accident or buys, let's see, a fire extinguisher and it explodes in his hands, and I sue on his behalf as his mother, I do not have standing because I am not the one who suffered the harm. He has to sue himself. So that is a limitation. The third limitation is ripeness, which means the case has to be ready to be heard. And so very often it can be properly asserted under the jurisdiction of the court. The parties can have actual standing, but the case may not be ripe for the court to hear it. And that may depend on a variety of factors. For example, there's no dispute among the lower courts yet, and the Supreme Court wants to wait until there is an actual case or controversy to be heard. They may hear it later on if it's not ripe now. The fourth limitation is that the court does not want to hear political questions. It does not want to intervene in matters that are more properly to be decided by other political branches. The executive branch, meaning the president, or the Department of Justice, or the legislative branch, meaning our Congress. So if there is an issue that is properly to be decided by another branch of government, the Supreme Court will not hear it on the basis that it is a political question. Now, if you have followed a lot of the news in the United States over the last decades, there have been a lot of discussions about what is or is not a political doctrine, what is or is not proper standing, when a case is ripe. So there are no black and white rules about these doctrines. They are subject to Supreme Court interpretation, but in theory, at least, they are limitations on the power to review. And the last limitation is one of mootness. And what that means is that the case no longer presents an actual case or controversy, or presents the possibility of actual harm to the parties. So if one of the parties dies, or the issue no longer is alive, it's no longer relevant, the court can decline to hear the case based on the doctrine of mootness. And there are some exceptions to that. For example, if it is likely that the issue is going to reoccur and reoccur and reoccur, the court can go ahead and hear the case because they just want to decide the issue and not keep receiving these cases. So those are some of the limitations on the powers of the Supreme Court. And so this here is the way that I started my talk, that really one of the fundamental roles of the Supreme Court is to serve as a balance wheel in the nation, to be a check and to be a balance between the executive branch and the legislative branch, between the central government, the federal government, and all of the states, between the states themselves, between the government and the liberties of individuals, and between the rule of the majority and the rights of individuals who may be in minorities. So that's the kind of the social glue function of our Supreme Court. So now I just am going to speak very briefly about the appointment and qualifications of Supreme Court justices. The appointment clause is set out again in our Constitution in Article 2, Section 2, which says the president shall nominate by and with the advice and consent of the Senate, the judges of the Supreme Court. And so this joint job between the legislative and executive branch is a way of sharing power between the other branches of government. So it prevents a concentration of power by the president, for example. It prevents a president from stalking the Supreme Court with only his political friends, because anybody that he nominates has to be confirmed by the Senate. And the confirmation hearings in the Senate are very tough. They're long and they're very detailed, and they can be very argumentative, and they're not easy. They're very difficult. This picture in the lower right-hand corner here is Justice Brett Kavanaugh, who is the most recently confirmed Supreme Court justice. His Senate confirmation hearing was all over television. It was very contentious. You probably followed it somewhat. It was very bitter in a lot of ways. He was confirmed, as you can see at the bottom of this screen here, very narrowly by a vote of 50 to 48 in the Senate. And it was strictly along political lines. So there were 50 Republicans who voted to confirm his nomination and 48 Democrats who opposed his nomination. But all it takes is a simple majority. It does not take a supermajority to be confirmed. Over the course of these years, actually, yes, this is right. Between the first confirmation hearing in 1789 and the most recent in 2018, and that was Justice Kavanaugh, who ultimately was confirmed, 163 nominations for Supreme Court justices have been presented to the Senate, and they have confirmed only 119 of them. You know, so that looks like a high number, but to me, that looks like it's very tough to get through the Senate confirmation hearings here. So the qualifications of justices, what do you have to have in your background in order to be a justice? And from the chart that I will show you in a minute, we have fewer qualifications than you have in Indonesia for your constitutional court. What the confirmation hearings look for is professional excellence. You do not have to be a lawyer to be on the Supreme Court, which frankly, honestly, was very surprising to me to learn. But you do not have to have a law degree. All of the justices have had legal training, but it's not required by our Constitution or by any federal law. Usually, the justices who are appointed to the Supreme Court have been federal appellate judges. So they have been federal judges already, but at a lower level than the Supreme Court. The one exception here, not the only exception, but one of the recent significant exceptions is the picture in the lower right-hand corner here. You all might recognize Justice Sandra Day O'Connor, who was the first woman who was appointed to the Supreme Court. She was not a federal judge at the time of her appointment. She was from the state of Arizona, and she was a state court judge. And that was very controversial for some people. Some people thought that all Supreme Court justices should have come from the federal bench. She was my opinion, was an outstanding federal judge. Once she got on the Supreme Court, she was a trailblazer for women like me who are lawyers, you know, who suddenly realized it was possible to be a federal judge. So during the confirmation hearings, the Senate is looking for professional excellence and an impeccable background. So if you, you may have heard, so for example, Justice Kavanaugh's contentious Supreme Court confirmation hearings had to do with charges about when he was in law school, that he was kind of rowdy and he was misbehaving. And there was a lot of cross-examination about that. There was, you know, during some of the confirmation hearings, there has been cross-examination about opinions or even law review articles that have been written, or you know, just your personal background. If you have a history of, I don't know, infidelity or drug use or corruption, anything like that, all of that will be looked into during the confirmation hearings. So tenure, how long does the Supreme Court justice hold his or her job? It's a lifetime appointment, which is why the confirmation hearings in the Senate are so detailed and so contentious, and they are fought so hard, because once a justice is on the Supreme Court, as long as she or he practices good behavior, she or he will never lose his or her job until resignation or until death. So this can be decades long. It can be 10, 20, 30, 40 years, 50 years maybe, depending on how old the justice is at the time of appointment. So this is a longer period of tenure than anyone in Congress, than any president is allowed to hold office, than anybody else. What is the argument in favor of lifetime appointment? It is that it protects the independence of the judiciary. If the judge knows that she does not have to run for office and does not have to seek reappointment, she can be true to the Constitution and to her sense of right and wrong, and write opinions and vote for opinions that are consistent with her best legal judgment and moral judgment, and not have to worry about running for office or about reappointment. What is the argument against lifetime appointment? Is that, you know, if you're not happy with the job that someone is doing on the Supreme Court, or you feel that that person is writing politically based opinions, you can't get rid of him unless he engages in misbehavior. And if the level of misbehavior rises to the level of high crimes or misdemeanors, the remedy is impeachment. So the impeachment process, you know, you probably recently saw the impeachment process against our president, Donald Trump, and it's very similar against a Supreme Court justice. It begins in the Judiciary Committee of the House of Representatives. They conduct an investigation, and if they decide that charges are warranted, they can file charges. And the entire House of Representatives votes. If a majority votes to impeach, the matter is referred to the Senate for a trial, and that's where the trial takes place. In the Senate, if two-thirds of the senators vote to impeach, the justice is removed from him or her office. And this just means if you skip all the way down here and you're reading ahead, you can see that only one justice in the history of the entire United States has ever been impeached. That means that his impeachment passed out of the House of Representatives and went to the Senate, but the Senate voted to acquit him. So he never lost his job. But if a justice is successfully impeached and removed from office, that does not mean that there will automatically be criminal charges. Criminal charges are separate. All it means is that that justice loses his or her job, and the president has a chance to appoint a new justice. So you can see here the most recent statistic as of December 2019, 66 federal judges or justices. This is not just on the Supreme Court. This is in the entire federal judicial branch, have been investigated for impeachment. Three of those 66 were from the Supreme Court. 2 of those did not even pass out of the House of Representatives. 1 did, but was acquitted by the Senate. So we have never had a Supreme Court justice who was removed from office because of misbehavior. So I am going to exit this right now. I don't want to take up any of Professor Susi's time, but I do have a chart that I would like to, let me see if I can pull this up. I created a chart which I think Ari can make available to you individually. That would be fine with me if he wants to do that. Let me just see if I can screen share it here. 1 minute. Okay, I think I've got it, Ari. Here we go.
Okay.
Is that good?
Okay.
Can you see it? Okay. So I'm not going to spend a lot of time going through this because again, I want to hear Professor Susi's talk. But what I did here, you can easily do this yourself too. And again, Ari, if you want to send it around, it's fine. But you know, I do a lot of advising for judicial systems around the world when countries are deciding whether to have a constitutional court, whether to redraft their constitution, whether they need a new constitution. And usually what people want is they just want to know how other countries have interpreted a lot of these laws and what they do in certain situations. So this is a chart that details, I have 14 countries on here. And again, don't worry, this will take me very short. I'm not going to go through them, but I just want to show you how to do this if you want to. So for each country, I've listed the article of the Constitution that's relevant, the age requirements for a judge of the Constitutional Court or the Supreme Court, whether or not there are any educational requirements, what the nomination and confirmation process is like, the length of the tenure or reappointment. And I think out of 14 countries, we are the only country that has lifetime appointment here. The rest have a term of office, whether or not there are citizenship requirements to be on the Supreme Court, any disqualifying factors, and then any other interesting information about the tenure and appointment process. So I just want to show you the countries that I've compared here. I have Indonesia, the United States. You can see we have no age requirements, no educational requirements. I mean, in theory, nobody even has to go to secondary school in order to be a justice on our Supreme Court. You do not even have to be a citizen of the United States to be on our Supreme Court. All right, so then I also compared France, Germany, South Africa, Thailand, Australia, India, Russia, Spain, Italy, and Nigeria, and Korea, and Colombia. So, you know, you can look, if Ari sends this around to you, and see the differences in the appointment processes for each one of these countries. But there are some significant differences. I will just tell you that usually the age requirement only specifies the maximum age. Like if somebody reaches the age of 70, they have to step down. The educational requirements, out of 14 countries, only 4 of them, including Indonesia, have specific educational requirements. Like you must have a law degree or you must have a university degree. A lot of the other countries do not have educational requirements, but they require prior experience as a judge. And then for citizenship, it's very interesting because 8 out of the 14 countries, including Indonesia, require citizenship in that country. that makes a lot of sense to me. I'm not quite sure why the United States does not require citizenship. But in any event, if you are thinking about legislative or constitutional reform in your country, you might find it useful to put together a chart like this, comparing how some of the countries that you're interested in have dealt with those issues: lifetime appointment, minimum age requirements, impeachment criteria, and that sort of thing, just to provide an objective comparison. So with that, I will stop and turn this over to Professor Susi, and I will stay so I can answer any questions at the end if you would like.
Okay. Thank you so much for Professor Warren for the amazing presentation. For the all participants, we also open the question. So if you have a question, please write your question down in the chat box. Don't forget to identify yourself by writing your name, and also if you come from abroad, please share your nationality too, and also your citizenship, because because we picked some questions from the chat box to be answered by the panel speakers, and also the best questions will get some book from Professor Herlambang. Okay, I don't want to wrap up from Professor Warren's presentation. Now it's turn to listen the lecture from another perspective. Currently, Professor Warren Currently, Professor Warren and Professor Susi admit raging pandemic in Indonesia. The newly CC laws draft proposed by the House of Representatives. The CC, or the Constitutional Laws draft, plan to revise some article, for example, about the minimum age requirement to be justice from 47 to 80, and also the article related to the tenure of justice from 5 years and can be re-elected for the second term into one term only until the 7-8 years old. So I think that we would like to hear the perspective of Professor Susi in seeing these situations or these issues. So I will give the microphone to Professor Susi. But for your information also, Professor Susi also has an experience in CC and constitutional justice selection process a couple years ago, if I'm not mistaken. So maybe Professor Susi can also share her experience to us. As known in Indonesia, the constitutional justice is nominated by 3 institutions. First, House of Representatives, 3. Second, President, 3 justice, and also 3 from the Supreme Court of Indonesia, or Mahkamah Agung. But the process or the mechanism of selection is quite different from one institution and another institution. If I'm not mistaken, all the candidates from Supreme Court of Indonesia is always the justice in the Supreme Court, or the justice or judge from the lower court in Indonesia. And also the process is quite close rather than or compared to the process, the mechanism did by the president institutions or the House of Representatives. House of Representatives is quite transparent, and the candidate is very broad, sometimes from the political parties, the political parties, and also sometimes from the scholar or academician. So without further ado, I call and I give the microphone to Professor Susi to explain her views on it. Thank you so much.
Thank you so much, Mas Ari. Good morning, all. I hope that all of you are in a good condition, since for a couple months we are all experiencing the pandemic, and I think that's a global disease. As far as I'm concerned, that so many victims, not only in Indonesia but also in other countries, such as in USA. I think the number of the victims has been rise significantly. I think in all countries, not only in Indonesia. Today, before I give my presentation, allow me to say thank you to Professor Herlambang to invite me to give a public lecture in this morning. And I congratulate to all of you at Universitas Bengkulu who celebrate the anniversary of your university, as well as your faculty, with the hope that your faculty bring a lot of contribution to the higher legal education in Indonesia. And I also very happy to see again Professor Christie Warren. We have met 2 years ago in Batu Sangkar, and we made a lot of conversation and discussion at the time. This morning, I will present about the powers of the Indonesian judiciary. So allow me to share my screen. Oh, hang on, I have to. Slideshow from the start. Okay. Can you see my slide?
No.
Not yet? Hang on. Yeah.
Okay, it's already.
So this morning, I will talk about powers of the Indonesian judiciary. And before I continue my presentation, as we all know, that the amendment of the 1945 Constitution made a very radical changes in terms of the judicial system. According to the original 1945 Constitution, we only have a Supreme Court at the apex of the court system in Indonesia. But as a result of the amendment, now Indonesia made a radical changes in terms of the system. And this is done in a way that Indonesia have two Supreme Court, that is the Supreme Court or the Mahkamah Agung, and the Supreme Court on the other area, that is the Supreme Court in the area of the constitutional cases. And we all know that this is called as the Constitutional Court. So if we read the Article 24 of the 1945 Constitution, I mean here is the amended 1945 Constitution. In paragraph 1, it is said that the judicial power shall be independent and shall possess the power to organize the judicature in order to enforce law and justice. So this is the main function of the Indonesian judicial, or the main function of the Indonesian judiciary, to enforce law and justice. And according to paragraph 2, the judicial power shall be implemented by a Supreme Court and judicial bodies underneath in the form of public courts or pengadilan umum, religious affairs court or pengadilan agama, military tribunals or pengadilan militer, and state administrative courts or pengadilan tata usaha negara, and by a constitutional court. So according to this paragraph, now the Indonesian judicial system will have, as I said before, we have two highest court. The first is the Supreme Court, and the second is the Constitutional Court. So this is the first distinction between the US judicial system and the Indonesian judicial system. So according to Professor Christie, that the US Supreme Court has the highest status in the US judicial system. Whereas in Indonesia, we have two highest courts that stand at the apex of the judicial system. The first one is the Supreme Court, or the Mahkamah Agung, and the second one is the Constitutional Court, or Mahkamah Konstitusi. And now we see about the Supreme Court, or we discuss about the Supreme Court. The Article 24A of the amended Constitution regulate the power of the Supreme Court, and you can read here that the Supreme Court shall have the authority to trial at the highest, or the cassation level, and then to regulate and regulation made under any law against law, and shall possess other authorities as provided by the law. So the Supreme Court, like the Constitutional Court, have power to review law, but they have the different jurisdiction. If the Supreme Court review the act or the law against or in conflict with the Constitution, but the Supreme Court will review the regulation below the law against the law itself. And here is the powers of the Constitutional Court that regulated by Article 24C of the Constitution. The Constitutional Court possesses the authority to hear the first and final level for review, and have the final power of decision in reviewing law against the Constitution, and then determining disputes over the authorities of state institutions whose power are given by this Constitution, then deciding over the dissolution of a political party, and deciding dispute over the result of general election. So I think that this authority, or the Constitutional Court authority, is quite different from the authority or the power of the US Supreme Court. So in terms of the Indonesian Constitutional Court, it seems that it tries what we call the political cases. So I regard that the scope of the Constitutional Court as a political cases. So first, the Constitutional Court have a judicial review power to review law against the Constitution, and then determining dispute over the authorities of state institutions whose power are given by this Constitution. For instance, for a couple years ago, the Constitution heard the case about the conflict of authority between the state audit institution, or the state audit agency, what we know as the Badan Pemeriksa Keuangan, with the executive or the government. So this is one of the example that the Constitutional Court heard the cases about the conflict authorities of state institution. And the next power is the deciding over the dissolution of political party. And this power has not yet carried out by the court. And the final power is the deciding dispute over the results of general election. And the interesting experience in regard to the dispute over the result of general election is as follows. A couple of years ago, the court decided that it did not only have the power to decide dispute over the result of general election in terms of the national general election, but also it will decide dispute over the result of local election, or what we call is pilkada, pemilihan kepala daerah. However, a couple of years ago, I think in 2017 or 2016, if I'm not mistaken, the court finally decided that the Constitutional Court has no longer to have a power to decide dispute over the result of the election on local head of local government. And it gives the clue that as long as the specific or the specialized general election court would be established, then the court will still carry out this power. This is the next authority of the Constitutional Court. So it does not only hear the political cases that set up in the Article 1, but it also shall possess the authority to issue a decision over an opinion of the DPR concerning alleged violation by the president and or vice president of this constitution. So this is the interesting mechanism now in Indonesia. Because of president and vice president are elected, directly elected by the people, as a result of that, the MPR has no longer power to make an individual impeachment over the president and or the vice president. So it seems that according to the amendment of the Constitution, or during the process of the amendment of the Constitution, the founding father of the amendment has to think how to make a proper impeachment process, because the MPR has no longer have the individual power to impeach the president. And then they came to the proposal that the Constitutional Court would be included in the mechanism of the impeachment of the president. And it is a good or it is a fundamental constitutional changes in Indonesia. And it also reflects the use of the principle of the rule of law in Indonesia. As we see that the Constitutional Court will be seen as a reflection of the use of the principle of the rule of law in Indonesia. So the mechanism of the impeachment of the president has now been changed. So previously, if the DPR allege that the president infringed the haluan negara of the state policy, and then the DPR will give a second or third times of warning. And then if the DPR had a decision that yes, the president infringed the state guideline, then the DPR would invite the MPR to conduct or to convene the plenum. And then in that plenum, the president will be invited to give a explanation that function as a accountability or accountability argument against the accusation. So, but now the mechanism of the impeachment of the president had been changed radically. The DPR still becomes a party to start the indictment of the impeachment, but the DPR will ask firstly to Constitutional Court to examine to what extent or whether or not the president and vice president infringe the article of impeachment that already set up by the 1945 Constitution. And once the Constitutional Court decide a decision over that opinion, then the Constitutional Court will convey again to the DPR. If the Constitutional Court approve approve the opinion of the DPR that the president, yes, already infringed one of the article of the impeachment, let's say, yes, the president has accept or received the bribery, then the DPR will invite the MPR to conduct a meeting, or what we call the MPR should make a rapat pleno. Okay. The article of the Constitutional Court, that set up by the Constitution, then elaborated by law number 24 of 2003, that already amended also by law number 8 of 2011. And the character or the nature of this law, it is called as the organic law. So the nature of this law is an organic law. What is the meaning of the organic law? The organic law is a law that set up or that enacted by the lawmakers based on the order of the Constitution. And we can see, for example, article, let's see, article 20. So 24, yeah, 24C, paragraph 6, it says that the appointment and the dismissal of the Constitutional Court justice, and then the law on procedure of the Constitutional Court, and other regulation in relating to Constitutional Court shall be regulated further by a law. So this is an example of what we call as an organic law. So law number 24 of 2003 and law number 8 of 2011 regarding the Constitutional Court is by nature is the organic law. And based on the article 24C, paragraph 6 of the Constitution, then the subject matters that regulated by such a law, including powers of the court, and then the organizational matter and law on procedure. So if the US experience show us that law on some of the law on procedure regulated by the Constitution that create the limitation of the Supreme Court to hear cases on judicial review, as Professor Christie explained. That is the legal, not legal, yes, that's the nature of a case that can be heard by the Supreme Court in America. So Professor Christie has already mentioned about case and controversy, and it is regulated by the Constitution. But here in Indonesia, the Constitution does not regulate the nature of the case that can be heard by the Constitutional Court. So if we read the 1945 Constitution, it only says that the scope, the jurisdiction of the Constitutional Court. And from that article, we can interpret that the nature of the cases should not or not cannot or it is possible for the petitioner to give or to ask the constitutionality of the statute, but not based on the actual harm, but based on the potential harm. So this is one of the difficulty to decide over the question of the legal standing. So this is one, once again, we see the difference between Indonesia and US. In US, it needs the concrete cases. But here in Indonesia, the Constitutional Court also hear the case of not only the concrete cases, but also the hypothetical cases. What I mean with the concrete cases here is quite different with the US practice. What I mean here, the concrete cases is refer to the petitioner itself. For example, in the case of general election a couple years ago, one of the petitioner is Effendi Ghazali, if I'm not mistaken. Yeah, his name could not be found at the list of the voters for general election, and as a result, then he brought the case before the constitutional court, asking the constitutionality of a law on general election, in particular that has a relation, or in particular that regulate about the right of the voter. And as a result, then the Constitutional Court handed down its decision that allowing the petition of Effendi Ghazali. And the court at the time said that if your name is not in the list of the voters that published by the authority, then everybody can use another type of identity, such as KTP or kartu tanda penduduk, and then the passport, and then kartu keluarga or family card, and so on. So this is what I say as concrete cases. Okay. And this is the roles of the Constitutional Court, the guardian of the Constitution, then the final interpreter of the Constitution, the protector of human rights, the protector of the citizens' constitutional right, and the protector of democracy. What is interesting among the roles of the Constitutional Court, you see that the Constitutional Court claimed that the court is the protector of human rights, but in the same time, the court is also the protector of the citizens' constitutional rights. Why I say that this is the interesting question, because according to the law on the Constitutional Court, only Indonesian citizens that have a legal standing. So in other words, foreigners do not have a legal standing. Foreigners cannot ask the constitutionality of a particular law before the Constitutional Court. So if the Constitutional Court insists that the foreigners do not have a legal standing before the court, how we interpret or how we read about the role of the Constitutional Court as the protector of human rights. So this is the interesting question that we can discuss in the Q&A session. And this is the appointment of the Constitutional Court justices. Yes, Professor Christie has already mentioned that the Constitutional Court shall compose of 9 persons who shall be constitutional justices and who shall be confirmed in office by the President, of whom 3 shall be nominated by the Supreme Court, 3 nominated by the DPR, and 3 nominated by the President. So we have 3 sources of nominating the Constitutional Court justice. And as mentioned by Mas Ari, we have the different mechanism. So the DPR, in my opinion, okay, it's transparent, but more politics in nature. The use of expert panel, but it seems only in a formal sense. So yeah, we have the expert panel, but we also have the power to decide the candidate, the final candidates. And then the president always have team of selection that consists of the academics, judicial commission, and former Constitutional Court justice, and sometimes also from the NGO. And in my opinion, it's much more comprehensive test, including healthy test, and then transparent. But the Supreme Court, as mentioned previously, much closed mechanism, and it only allowed the internal candidates. That it means that judges from the Supreme Court or the lower court. This is the requirement of constitutional justices that's set up by Article 24C, paragraph 5. So each constitutional justice must possess integrity and a personality, that it is not dishonorable and shall be fair, shall be a statesperson who has a command of the Constitution and the public institution, and shall not hold any position as a state official. So yes, based on my experience, when in 2018, I followed the selection to become a constitutional justices in that selection process before the expert panel. At the time, the panel asked several and various questions to me, not only constitution, but also my opinion regarding a specific issue. For instance, I still remember that one of the members of that panel asked me, if we have a division between the original and non-original justices, in what classification that you tend to be, whether the original or the non-original character. And it means the member will consider about the tendency of my standing, whether conservative or much more liberal interpretation. Now, so this is the appointment of the Supreme Court justices. The Article 24A of the 1945 Constitution. And this is the picture of Professor Bagirmanan, the former Chief Justice, and Dr. Harifin Tumpa, that also used to be the Chief Justice of the Supreme Court, his successor of Professor Bagirmanan. So unlike the appointment process of the Constitutional Court, the appointment process of the Supreme Court justices involving the Judicial Commission. And this is because the Judicial Commission has the power to make a nomination of the Supreme Court justices to the DPR, and then the DPR will make a fit and proper test. Okay. This is the mechanism, the selection process conducted by Judicial Commission, and the candidate, mostly career and non-career judges, and several stages of selection process, such as the administrative process, then writing academic paper, drafting a court decision, and so on. And also the final interview before the panel of the expert. And this is the requirement of the Supreme Court justice. More or less, it's quite similar. And this is the current issue about the judicial review that relate with the Constitutional Court jurisdiction. Here in Indonesia, the Constitutional Court make a distinction between the formal review and the material review. The formal review refer to the review that regarding the process of the lawmaking, whether the process itself consistent or inconsistent with the principle or the norm of Constitution. And then the judicial review by the Supreme Court. And yes, as mentioned by Mas Ari, the judicial review that carried out by the Supreme Court much more closed process in comparison with the review that conducted by the Constitutional Court. And this is the last issue is a very hot debated issue, a bill concerning proposed amendment of law in the Constitutional Court, in particular, matter on minimum requirement of age. Currently, the minimum requirement of age is 47. But according to this bill, the minimum requirement age is will become 60. So you can imagine that how we can have a very high qualified the Constitutional Court justices if that bill only give an opportunity to the people that minimum 60 years that can apply for the position of justices of the Constitutional Court. But still, I'm not quite sure how is the response of the government. But the bill is already given to the government, and then we still waiting. We are still waiting for the government respond to that bill. If the government regard that bill, this bill is no longer important, then maybe the government will make a letter informing the DPR not to debate this bill in the parliamentary debate process. That's the brief explanation about the Indonesian judicial system, and we can elaborate the issue in a question and answer session. Thank you, Mas Ari. The floor is now yours.
Thank you so much for the fruitful discussion and presentation, Professor Susi. Can you hear my voice? Hello? Can you voice? Okay.
Yes.
Okay, thank you so much for the fruitful discussion and presentation by Professor Susi. Now we go to the third agenda. It is the questions and answer. It is the questions and answer session. We just already picked some questions from the chat box and also from the YouTube channel. So I will try to conclude some questions with the similar term. First, the questions about what is the question for both of you, Professor Susi and Professor Christie Warren. What is the fundamental difference between the judicial power having by the Supreme Court of USA, the Supreme Court of America, and the Supreme Court of Indonesia? I mean that Mahkamah Agung and also the Constitutional Court of Indonesia. Second question is about, I would like to ask both of the presenters, do Indonesia and America have the potential to apply an effective judicial method by French called ex ante review, or known as judicial preview? It's a method that let the Constitutional Court participate to the legislative making and ensure that the bills are constitutional. This is the first two questions for both of you. Professor Warren, can you understand the question? Sorry, can you turn on your microphone first?
So see, that's an example. I was saying you will have to forgive me because it's almost midnight here and my brain is starting to fall asleep. So can you repeat the first question for me again?
The first question is, what is the fundamental difference in the judicial power between Indonesia and USA? Because we have two actors, like judicial power in the Constitutional Court and also the judicial power in the Supreme Court. And what is those kind of product of laws can be reviewed by the Supreme Court of USA? This is the first question.
Yeah, so let me start with that one, which is, I think Professor Susi did a really good job outlining the difference between the two apex courts in Indonesia, the Supreme Court and the Constitutional Court. And we don't have that difference, as I pointed out. Everything is reviewed by one apex court, the Supreme Court. But the way that it narrows down the cases that it accepts makes it operate very similarly to a constitutional court and not just the highest appellate court. But I think there were other interesting aspects of Professor Susi's lecture, like we do not get involved at all in political party matters, dissolution of political parties, political issues. As I pointed out, if something is determined to be a political question, that is something that the court system is not supposed to get involved in intervene in. You know, if you look at a lot of the cases that have been, not a lot, but if you look at some of the cases that have been decided, even in recent years, for example, presidential elections, you know, people say, well, that is absolutely a political question. You cannot, you know, you can't say that it's any other thing. So that's why I said a lot of these limitations for standing for mootness for political question are not black and white. They're not hard and fast. They are subject to interpretation and reinterpretation, but they still are supposed to serve as limits to what is reviewable by our judicial branch. And I think, as Professor Susi so beautifully pointed out, you know, the limitations of judicial review in Indonesia are just different, not only because there are two different institutions, but just whatever is within the scope of the power of those institutions is articulated differently in your constitution than in ours. That is not to say that one is better than the other. I mean, that was the purpose of that chart that I showed you, which is none of us, in my opinion, in the world should be trying to copy one particular model, whether it's Germany or Spain or Britain or the United States or India, whatever. There are many different ways that cases can be resolved and many different ways to formulate those rules, and different systems have done it in different ways. So I think those are some of the basic differences. And the second question I didn't really understand, so I'm going to leave that to Professor Susi. I'm sorry, I think, and I'm also having a little trouble hearing. So maybe you could hear that question better than I.
Okay. Before you leave, can you answer one question again, Professor Warren? Because some question is quite the same about the citizenship requirement for be justice in your country. What is the implication? Do the Indonesian, for example, can apply as the Supreme Court Justice in United States or not? Can you elaborate more?
Yes, I mean, yes. That's why I said it was when I was doing this research, I was surprised to find out there's no citizenship requirement to be a Supreme Court Justice. I mean, there is one to be president, you know, because when President Obama was president, a lot of his political opposition was because people were saying he was not born in the United States and he had a false birth certificate. So people take those citizenship requirements very seriously. There is no citizenship requirement to be a Supreme Court justice. So in theory, Professor Susi could be on our Supreme Court. Professor Ari could be on our Supreme Court. Now, I will say that the Senate confirmation hearings, I think, will serve as a limitation on that, because I think it would be difficult to succeed in a Senate confirmation hearing if you are not a citizen of the United States, just because we only have 9 justices. They are very, very well respected, and people see the Supreme Court as being symbolic of the United States. So although there's no technical legal requirement for citizenship, I think politically and practically it would be difficult for someone who is not a citizen to become a justice.
Okay, one short question. I know you want to leave first because it is 10 p.m. right in America, right? But one short question.
No, I will stay. I will stay. I will stay.
One question for you first. Based on the history or the experience, do the people outside, I mean the non-American, apply for the justice to be justice in America or no?
I don't know the answer to that. I don't know the answer to that. I suppose it is possible that someone with dual citizenship, you know, because you can be a citizen of 2 countries at once. A lot of people are. So I think it is more possible that someone with dual citizenship may have tried to become a Supreme Court justice. I just have not done that research, so I don't know whether in fact anyone has ever tried. As soon as we finish, I will Google it and find out.
Okay, we go to Professor Susi. Our first question is about the fundamental difference between the judicial power having by Indonesian judicial power system and America. Second, about the possibility for the Indonesian judicial power for having the judicial preview, not judicial review. What is your opinion about that, Professor Susi?
Okay. Thank you for the question. Before I answer that question, I will respond to the Professor Christie Warren answer. And I think that, yes, you are right, that we have a different judicial system in terms of the highest court, that US only have the Supreme Court that stand at the apex, whereas Indonesia have the Supreme Court and the Constitutional Court. And here in Indonesia, we have to consider about our past experiences. So during the process of the constitutional amendment, there are a number of proposals at the time about the necessary to review the constitutionality of the law. At the time, the proposal is whether the power of review of the law would be given to the MPR, and then to the specialized court, or to the Supreme Court. So there are, that's the proposal during the constitutional amendment process. So each of the proposal have a strength and weakness. If the review of the law would be given to the MPR, it meant that the MPR is a political body. And as a result, then the review that conducted by the MPR would be political in nature, not legal in nature, not legal review, not judicial review, but political review. And then the consequence, if the proposal, the second proposal would be chosen, that is giving the power to the Supreme Court. At the time, the Supreme Court has have a backlog of case, more than 50,000 cases, maybe approaching to the 20,000 cases. So if the Supreme Court would be given an additional power to review the constitutionality of a state, then it is a question whether the Supreme Court have an adequate justice to carry out the additional power. And then the third proposal that is decided and chosen by the founder of the amendment of the 1945 Constitution, that is to set up the Constitutional Court, separate from the Supreme Court. And in this context, it seems that Indonesia follow the experience of the Austrian rather than other country that what we call categorized as a common law country, common law judicial system. So we choose the separate court for reviewing the constitutionality of a state. That so this is again, we have to understand the need of each of the country when set up the constitutional system to respond the need of the people, because at the time there is a huge number of questions about several statutes that already enacted by the DPR and the president. So at the time, the critical question is whether can we accept a statute that we regard have a matter that inconsistent with the Constitution. So at the time, that's the critical question from the people. And that's my first response. And then my second response is that, yes, the difference between US and America, US and Indonesia in terms of judicial review be found at the limitation of conducting of judicial review. I learned from the US experience. US experience, in my opinion, is quite good experience, is very good experience, because the Supreme Court made a limitation when it conduct the power of judicial review. And that limitation comes from the constitutional limitation that is referred to the Article 3 about the judiciary, that the Supreme Court only hear concrete and controversy, case or controversy. And then the second limitation that we call the policy limitation. And the Supreme Court developed a policy limitation based on several decisions that already handed down by the Supreme Court. And here we know about the Aswander rules, Professor Christie.
The what rule?
Aswander rules. Yeah, the Aswander rules that the Supreme Court make a self-restraint to accept which a case that will be heard by the Supreme Court. So that's based on the Aswander rules. And the third limitation is that limitation that is based on doctrine. What Professor Christie has already explained before, that one of the limitations of the doctrine that relate to the legal standing, the actual harm suffered, and then the political cohesion doctrine, and then the ripeness and the mootness. That's the doctrine. Now, that's the limitation. In my opinion, the Constitutional Court of Indonesia has not yet developed that limitation. So I think this is time now for the Constitutional Court. This is urgent to start a development in terms of the limitation in conducting judicial review. To some extent, the Constitutional Court looks like give a very flexible assessment in regard to legal standing. So, for instance, when Effendi Ghazali brought the case on general election, he only gave a claim as a taxpayer. So, the legal standing based on taxpayer. So I think it is time now for the Constitutional Court to start to develop the limitation of the judicial review. Okay, so this is the second response to Professor Christie explanation, and then now I try to answer the question whether Indonesia could apply the constitutional preview. Again, I will, if I'm not mistaken, French constitutional or French constitutional review is already changed. So I think that France not only conduct preview, but also conduct review. So the double track, preview and review. When the constitutional or the Dewan Konstitusi or the constitutional what we call the Dewan Konstitusi constitutional
Constitutional Council.
Yeah, Constitutional Council. So when the Constitutional Council carried out its power to conduct a review on constitutionality of statute based on the concrete cases. So it has a power to review constitutionality of a statute based on concrete cases. But in the same time, France is also applying the preview. And the France just said that when it is asked, oh, it seems that you follow the US system conducting a review of constitutionality of a statute based on concrete cases. And then it replies that no, this is our response. This is our response how to accommodate the need of the people as a whole. So this is the constitutional innovation that possible made by each of the country. So if Indonesia, if the people of the Indonesia will also ask the constitutional court to have the preview power, so I think the MPR should have think seriously, because it will result in a very huge fundamental changing in terms of judicial system in Indonesia. We can learn from France. What is the strength and the weakness having a dual system, review and preview? So we have to think seriously about this proposal. Thank you, Mas Ari.
Okay, I think this.
May I ask one question here? When you talk about preview, are you talking about the advisory opinion before legislation is enacted, where the Constitutional Court will preview whether the proposed legislation is constitutional? Is that what we're talking about?
Yeah, exactly.
I'm sorry, I had my ears out.
Yes, exactly. We are
Okay.
talking about, we are talking about look like advisory opinion.
Yes, yes.
Much more legally binding. Okay.
Yeah.
The experience of like the France experience.
Yeah. So I would just say, you know, that there are implications on the caseload either way, because if the court takes on a role of giving preview powers, advisory powers, its caseload can double or triple hugely. On the other hand, in the United States, we don't have that power. And so, for example, Congress frequently drafts legislation that is very messy and has gaps in it or duplicates parts. And when people read legislation that comes out, they say this will take 10 years before it can be implemented because it is very poorly drafted. An example of this was, I don't know, 15 or 20 years ago, we passed in Congress the Americans for Disabilities Act. And it is meant to protect people who have disabilities by giving them rights and protections and access in public buildings. But it was so poorly drafted that it has had to go through decades of review in the courts before it could even be implemented. And so critics say, well, if we had advisory opinions in the Supreme Court, we could have saved 20 years worth of litigation by just asking them to clarify this bill, this act, before it became law. You know, so in that way, it really could reduce caseloads within the court to at least have advisory opinions before something's enacted. So I think there are no clear answers either way, but I do think you are right to look to a country that has preview powers to see what impact it has had on the caseload of the court.
Okay, thank you for the explanation, Professor Christie Warren and Professor Susi. For your information, for all the participants, the link of the presentation will be shared in this time in the chat box. So please fill your name in the list of the attendants, because the certificate only will be given for the participant who fill their name in this presentation. Professor Warren, we go to the last question before we closing. This question is personally for Professor Warren from Lina. Thank you for the enlightenment. The first question is the Supreme Court took the small number and limited cases from the thousands of cases. It means that the judges of the Supreme Court of America try to maintain his power carefully. How the mechanism to choose which one the cases will be evaluated or heard by the Supreme Court?
So that's a very good question because everyone, you know, if you're a lawyer and you are litigating a case and you want the Supreme Court to review your case, you are so interested in finding out how to go through that very small door. But the Supreme Court justices and their law clerks do review every single case that is sent to the court to decide whether to accept it or not. Each justice has 4 or 5 law clerks who assist the justices in making that decision. Every Friday, the court meets in a conference, and the purpose of that conference on Fridays is to discuss which cases should be accepted and which should not be accepted. And they have a system of voting. We have 9 justices. They have a system of voting within the conference about who thinks a case should be accepted or not accepted. So there's a very thorough review process. What I will say is that it is done confidentially. So there is no record of those discussions because the justices feel that it's very important that they be able to express their opinions freely and speak freely and have a good debate among themselves without the Washington Post reporting on what they're saying or anything like that. So we don't actually know what goes on during those discussions or who voted to hear a case and who voted not to hear a case. But every case that arrives in the court is reviewed to make that decision. And it is a very small number of cases. It's a very, very small number of cases. And there are criticisms against the Supreme Court because of the small number, but their position is that they are not a simple appellate court. The intermediate federal courts, so if you think about the district courts, the district federal courts are where the trials happen of first instance. And then there's a right to appeal for the federal circuit courts. And for almost all cases, that is the final level of appeal. In that way, you only get into the Supreme Court if there's a constitutional issue or an inconsistency in the application of law down below. So it is not really a cassation court, truly a cassation court like France has. But it's very similar in a way that there has to be a very extraordinary and important reason for the case, for the court to take that case. It's not just because a party did not like the appellate or the result on appeal there.
Okay, thank you so much for the explanation. I think before we go to the closing remark by Professor Herlambang, I will allocate 3 minutes for both of you to conclude our series, our study in general today. Maybe start with Professor Warren first and then Professor Susi.
Okay, well, again, I think I would just like to thank all of you. It's been so lovely just to be back in Indonesia virtually, one of my most favorite countries there, and to see so many familiar faces. And I thank you very much for inviting me. The discussions that you are going through, the issues that you are deciding are so important and they are so fascinating. And there are many models around the world for you to look at and to decide what might be appropriate in Indonesia. There are a lot of experiences to be shared. And I think the people who organized this conference, and certainly Professor Susi and Professor Ari and I, all consider ourselves comparatists. And what that means is we like to look at what all of the different options are. We don't want anybody telling us, oh, you need to make this decision because it's politically the best decision, or you know, we don't believe in that. We believe in studying the various options that are available and talking to people who have worked in those systems so that you can make your own decisions about what will work best in your country. And I highly encourage you, while you are debating these issues, for example, about limitations in the exercise of judicial review, and should your constitutional court hear 4,000 cases per year or maybe 100? I don't know. These are decisions for you to make, but there is a lot of experience out in the comparative world for you to take advantage of. And that is, I think, why this kind of a conference that you are having is so important right now. And despite the sadnesses that go along with coronavirus and the limitations, and we are all so tired of being locked up, the advantage to a Zoom conference like this is that you can see people from a lot of different countries and listen to their experiences. And so I encourage you to keep doing that. And I thank you for listening to us during this seminar. And I hope someday to see you again in person.
Professor Susi.
Okay, thank you, Mas Ari. What I like from this conference is that we encourage to the development of comparative law subject. So, and it is a good way of method of learning or a method of teaching in legal education in Indonesia, because the resource person directly come from other country, that is Professor Christie Warren, and it is a very good opportunity for all of you to directly ask and discuss your concern about the judicial system in other countries, and then try to make a comparison with our countries, and then we can assess or we can examine which part that we can adopt or adapt, which that should meet with the necessary of the Indonesia. Yes, as Professor Christie said, that we can make a judgment that a particular country system is much better than the other country, is suit with the other country. Each of the system has its own uniqueness, and that uniqueness should be in line with the history of the country, and then the necessary aspect of the necessity of that people, and the growth of the society. So what is the best learn from this conference is that we can learn from the experience that of the Supreme Court of the United States of America. Then after that, we can make a brief, not brief, yeah, but we can make an assessment to our own judicial system. If we want to change, or if we want to make a better design, then which part that we can borrow from other country, with the several criteria that should be met with the necessity of the people of Indonesia. And in this conference, I would say thank you to Professor Herlambang for inviting me for the second time to involve in discussion that organized by your faculty. And also I want to say thank you to Professor Christie for your explanation. It's always lovely to meet you, and although through virtual event. And I also want to say thank you to Mas Ari, who already perfectly organized our morning discussion here, but midnight discussion in your country. So I'm so sorry, Professor Christie, to disturb your time. And once again, I also want to say thank you to all participants, to all of you that already raised your question, that already raised your concern about the exercise or the practice of the judicial system in Indonesia. And I hope to meet you again in next academic event. Thank you, Mas Ari. Thank you, Professor Herlambang. Thank you, Professor Christie.
Okay, one thing that I learned from the comparative study is about the cherry picking theory, to take the good one from the others and let the worst gone. I think this is the good theory about the comparative study, about the cherry picking theory. Okay, now we go to the fourth agenda, the closing ceremony. I mean that the closing ceremony. We will invite Professor Herlambang to close officially this event. To Professor Herlambang, time is yours.
Thank you very much. I will make a conclusion because Professor Warren and Professor Susi have made the conclusion, very good conclusion. The end of the conference, I'd like to say hello to many participants from the Sabang, the west of Indonesia, and the Merauke, from the Papua, and many friends, academic lecture, all from the whole of part of Indonesia, Manado, Kalimantan, and maybe this is the way we will reach to change the information about the knowledge of law and use the Zoom and virtual, not direct meeting. Okay, thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Okay, thank you so much. I think that's all. This is the end of our seminar today. Happy anniversary for the Faculty of Law and also the Universitas Bengkulu for the 38 years anniversary. Thank you, Professor Warren. Sorry for interrupt you in the midnight. And also thank you, Prof. Susi, for joining us again. Oke, mungkin demikian Bapak Ibu sekalian cara kita pada hari ini. Silahkan mengisi Google Form untuk presensi dan mendapatkan sertifikat. Sertifikat akan langsung dikirimkan melalui email Anda, dan pemenang dari door prize akan dihubungi secara langsung, atau silahkan kunjungi Instagram Fakultas Hukum karena kami akan umumkan di sana. Mungkin demikian, wabillahi taufiq hidayah, wassalamualaikum warahmatullahi wabarakatuh. Good evening, Professor Warren, and good morning for Professor Susi and the others. Bye. Makasih, Prof.
Thank you, Professor.
Terima kasih. Thank you.
Terima kasih banyak. Thank you.
Izin
Terima kasih.
Prof. Herlambang.
Prof, udah selesai ya, alhamdulillah.
Thank you.
Thank you.
Okay.
Bye.
Nanti bahan juga akan dikirim via WhatsApp dan
Thank you. Thank you. Thank you. Iya.
Selamat izin, Prof.
Itu karena mobil paling belakang. Ini yang bukan.
Duit, dengar.
Pak Herlambang, kenapa nggak bisa tanya? Aku mau tanya.
Lewat
Ya. Tanya apa tadi?
Sudah tanya di chat tadi, perbandingan antara penjujutnya ada di US, kemudian perbandingannya lagi dengan pasal 24 ayat A. Sudah di chat lah, sudah nunggu-nunggu nggak jadi. Nggak apa-apa. Untuk webinar berikutnya, Pak ya. Makasih banyak, Pak. Saya Dr. Iis dari University 17 Agustus 45 Samarinda. Sudah dibikinkan kah linknya absennya ini yang untuk
Sudah, Pak.
Halo guys. Apa loka tuh, Co? Nggak ada loka. Ngapa tinggal kita-kita, Bang?
Arif, kau ribut Bang, kau ribut.
Apa?
Ribut baik kau ribut.
Tidak, mau tuh memperhatikan. Woi, Pak Anjas.
Woi, Rif.
Pak Anjas.
Ya elah.
Untuk link Google Form untuk sertifikatnya itu di mana ya?
Ya, kinian.
Terima kasih Bapak Ibu, izin lab. Assalamualaikum.
Oh,
Waalaikumsalam.
Waalaikumsalam.
Sertifikat tuh nengok di chat, Bang. Lihat di chat tuh, Bang. Ada isi absensi. Ada linknya tuh, Bang. Di mana nengok absennya tuh di mana, cuy? Ada di more, di chat. Coba lihat.
More tuh
di grup kan, Di Zoom dulu lah, Di Zoom
Enggak ada ya?
Chat Zoom dulu ya.
Keluar dulu, tidak.
Absensi. Tidak usah dikeluarkan, Coy.
Jadi yang mana ditekan tuh?
Kau klik yang layar kau, tuh ada bacaan more.
More tuh di mana?
Iya, mana more tuh? Ada more ya. Ada chat. Ada chat.
So name when participant join.
Oh,
iya. Oh, ada ketemu more.
Link absensi.
More aja lah.
Bara kalian kok.
Yang mana, Dep? Yang name when participant join.
Klik dulu. Layar kamu tuh diklik dulu.
Wait, yang mana?
Inilah kamu nih corang
Wait, Jas, yang
dusun.
mana, Jas?
Corang dusun. Kau nak ngomong kan? Satu-satu, woi.
Kemalu,
Alah kebanyakannya yang ngomong kok. Itu lah
Belago.
dusun. Belago.
Mana?
Yang mana, woi?
Klik layar tuh.
More kan?
Ada bacaan more dah.
Aduh, sudah terus.
Nah, terus ada bacaan chat.
Aduh. Chat.
Nah, bukalah tuh. Nah,
Oh,
satu
oke
ada
deh.
link absensi.
Mana? Coba kau absenin nomor.
Dem tuh berarti di Google Form nih.
Ayo nyela tuh, Co. Nyela.
Diklik.
Klik. Yo, diklik.
Dem tuh
Bikin nama kalian
nah,
terus
isi nama yuk.
asal kuliah dah.
Tempat di tempat saya udah ada kan?
Di dusun ngerti. Nah, kau isikan absen dulu.
Mana absen?
Nama. Ayo,
Tolong kau
kirim dulu link.
Aku kirim
lagi link ke sana. Coba pas sana.
Jangan keluar dulu kamu tuh. Awak belum.
Apa kau, Yip?
Mekak Tiko.
Kirim lagi link ke sana.
Asal kau isi apa asal kau?
Asal tuh kuliah, Co.
Kuliah pasca sarjana Unip, udah bela itu
makan tuh Mbak Vera. Yakin.
Ya, udah
Kirim,
kata Yip.
kita kirim link lagi lah.
Aku kirim lagi yo di chat yo.
Oke.
Tunggu dulu, jangan keluar dulu. Kirim. Kirim kok. Aduh, kalian kok. Woi kubu. Iko kok di screenshot apa cuman Dit?
Enggak usah di screenshot.
Udah absen kuliahnya udah langsung otomatis yang dikirim.
Otomatis. Kelak tuh di grup kelak tuh ada bacoannya kelak tuh. Di grup itu masing-masing kelak tuh.
Jadi kan chatnya kan hilang.
Nah, kirim di grup linknya tadi.
Linknya
Oke,
ke grup.
siap. Ambil link dulu ya. Assalamualaikum.
Tunggu dulu
Kirim
deh.
ke grup. Kami tadi pas nak absen keluar
Azza,
Zoom-nya.
kirim kamu juga Azza.
Pak Jas.
Pak tinju nahan kok, Pak.
Tinju Jas. Takut balik.
Pak nak mati nah kau nih.
Belum ada di grup, woi.
Kona.
Azza.
Nah, kena habis.
Susi kan masih
Email lagi.
Kirim ke grup WA tuh, Dit. Yo, sudah aku kirim.
di situ nggak dia tahu.
Lip dulu yo. Assalamualaikum. Jangan dulu, Dit. Udah emang bu? Sudah. Kita kok lagi on YouTube, Jir. Lagi YouTube kita kok. Linknya.
Kirim di WA grup 3 ada tak?
Apa?
Yang grup 3.
Oh lah tidak ada lagi. Keluar.
Abang pakai apa, Bang? Pakai HP apa pakai apa laptop?
Tak ada lagi dia.
Kalau yang pakai HP diklik aja di layarnya tuh. Beda ada. Benar tak yang kamu kirim ke grup tuh, Dit? Kalau pakai laptop tuh cek Bang di apa? Di menu. Menu Zoom tuh lah. Dalam Zoom tuh lah. Lalu ada baca nomor.
Kalau balik ke rumah dan balik
Radit. Oi. Benar yang kamu kirim ke grup kelas.
Sudah. Nyala tuh.
Benar tuh?
Benar.
Oke, thank you, Dit.
Yoi, bro.
Belum saya udah ada dapat link.
Beli linknya.
Itu pengarahan dari detik lagi.
Iya. Jadi disuruh ngap. Ayo Ayah.
Oi. Halo.
Mana panjas? Mana? Iya.
Enggak
tahu. Nomor HP-nya enggak tahu, email enggak tahu.
Disuruh apa ini?
Halo.
Bawa headset.
Apa lagi nak takut lagi aku ngapa? Oh, nanti tahu. Tahu makan kayu. Tas. Ini enggak penting nelpon aku. Yang kerja.
Mak. Lagi di sekolah, Mak, kok, Mak.
Apa email? Anjas Marena.
Ngapa kak? Ngapa? Sorak.
Mano.
Anak tiri. Anak tiri.
Di sini.
Hah?
Di sini nanti. Di sana belum tentu.
Di sana tuh di mana?
Hah?
Dede. Aman lah. Selagi pemilik villa di mana tuh Rakiti itu masih backup aman gitu. Pemilik villa di Rakiti ya.
Deh, berapa nomor Kak Anjas nih deh, nomor HP-nya? Kau dektekan deh. 08 nyontak kemana? Nggak dia dapat. Rugi lah berjam-jam.
Ada yang lebih kan?
Kosong 821
Suara apa itu?
nih. Play.
link absensinya belum ya?
Ini yang stadium general kan?
Bapak DP nanti si foto mengaku baru tadi lagi curang.
Mana pisau? Gitu memang tarik. Berani, coba dulu. Pisau. Yuda, paham enggak? Agak itu. Boleh Pak? Enggak, Pak. Itu gue.
Mana? Hari apa bukan jalan? Apa di sana?